and welcome to Stowe Talks, a podcast designed to support people going through a relationship breakdown and all the challenges this brings. I'm Matthew Taylor.
And I'm Liza Gatchell, family lawyers at Stowe Family Law. And today we're looking at what your options are if your ex-partner will not respond to your divorce or further down the line, financial disclosure in the Form E. So let's start with how common is this, Matt, in your experience?
It's not uncommon. It's not. It doesn't happen in most cases. Most people do participate and do engage in the proceedings and understands that that both people engaging is going to make it quicker and less painful. And then there's a bit of a spectrum of non-engagement, from the stick your head in the sand ostrich type who will eventually do stuff but is a bit of a pain in the backside to get engaged, right the way up to people who either refuse to or dodge service or have already disappeared off the face of the earth, that have kind of deserted the marriage and genuinely, a client doesn't know where they are. I mean, is it something that crops up frequently for you?
No, I don't think it crops up too often. And actually, I think it's probably less of an issue now that we've got the no-fault divorce. I think previously when we were dealing with adultery petitions and unreasonable behaviour petitions, there would perhaps be a tendency for one party to read that petition, not like the contents of it, and then absolutely say, I'm not signing my name to sort of that particular document. And we'd have to have sort of big discussions as to the fact that they didn't have to accept what was in the document to be able to let it go through and all the rest of it. Whereas I think now that we have a no-fault divorce, that is kind of a problem of the past to a certain extent. Don't really have an issue with people not responding. I think finding people can sometimes be more of an issue if we don't have a contact address for the other party. That probably poses more of a problem, I would say, these days.
Well, shall we start with that then? When you have that and you can't track down someone's spouse to get the divorce served or to write to them about the finances or whatever it may be, what steps are you taking then to try and find out where they are and get things going?
So one of the things that we can do is we can speak to an inquiry agent or a tracing service to be able to see if they can locate them through council tax records, etc. They have all sorts of, I don't pretend to know what it is they do, but they do often come back. They do often come back with an address.
They just somehow know things.
Yeah, they will often do it, and they often do it for a sort of no fine, no fee, on a no fine, no fee basis, which can be really helpful. So that's one way of doing it. The other way is if we perhaps don't have a residential address, but we do have, for example, a Facebook account or a mobile telephone number, etc., then we can try and initially contact them through that. That's not good service initially. And if it got to the point that they still wouldn't provide us with the information to be able to sort of issue the application properly, then it may be that we would have to apply to the court for what we call substituted service. So that basically means being able to serve them via an alternative format. And that might be via WhatsApp with your 2 blue ticks, or it might be via Instagram messaging or Facebook messaging or however it is, or email in some circumstances.
Yeah, I think that's often the first port of call because, well, not necessarily the first port of call. The traditional service requires it to be posted to last known address and for some sort of evidence that service has been received. I mean, I don't really think too many people want this to turn into an in-depth podcast on the family procedure rules and the civil procedure rules about service. God knows I don't. But you do have to kind of demonstrate to the court that a document has been received. And normally the way of demonstrating that is someone responds to it. And that's the way you do it. If they don't respond, then there are certain things you can do. You're right, substituted service. So all manner of creative ways of serving people, and there have been cases about WhatsApp and so on. But you need the court's permission to do that. Well, firstly, if you think someone has received it and you've got some sort of evidence, so you have, for example, you've used one of these process servers, you have sent them to the address, they provide a statement which says, I saw Mr. Smith and I rang the doorbell and he said he was Mr. Smith and he refused to come to the door and therefore I put it through the letterbox, so he's got it. You can apply for that, and then you can apply for an order of deemed service where the court deems that it has been received. So, you can use these things to say to the court, look, court, come on. The respondent's obviously got the documents, just make the order it's been received, so then you can progress with the divorce or whatever. I think the other the way to do it is you can make an application to dispense with service, where you don't have to serve a document at all. And that's really, if you have, and that's quite hard. You need to exhaust.
It's really
absolutely. Dispense service is really difficult. It's a really high bar. You need to show that you've been all around the houses. You've tried to speak to your spouse's family, friends, the Department of Work and Pensions, HMRC, you name it. It's really difficult bar. It's less common, but that's your option. But generally, if someone won't engage in the divorce process, you only need them to engage for the first bit, to acknowledge they've had the application, and then you can drive things forward as the applicant. So it's probably not such a big issue. Where the lack of engagement can be a really big issue is with the finances, because that is a two-way process that involves some buying and some engagement, and you can't just get someone to acknowledge something once and then it's done with. So I mean, Lisa, what are some of the common things that crop up with someone who maybe doesn't want to start getting into financial disclosure or whatever, and how can you make them do it?
It's quite varied, isn't it? I mean, we go from people that will just completely ignore us, or not ignore us, but tell us they're not going to do whatever it is that we want, we're asking them to do, to people that are providing some information, but not all of the information, and it's kind of being drip fed and there's big gaps, etc. So we've got a spectrum of things here that I suppose that we're covering. We've talked about it a lot on the podcast, that ideally your starting point with trying to sort out finances is to do that voluntarily, do it through forms such as solicitor negotiations, talking to your ex-spouse, going to mediation. But the reality is if your ex-spouse is not providing you with any of the financial information to allow those voluntary discussions to take place, you get to a stage where they're going to force your hand a little bit, and it gets to the point where your only option is to make an application to court. So we can write to them, we can refer you to mediation, we can ask for Form E's to be completed voluntarily, but if they're not going to do it, then the next step is to issue your application to court, because one of the first court directions will be to file a Form E financial statement. So that's the document that will detail all your property, income, assets, liabilities, etc. So should provide all of that information. And again, if they provide that information and it's half, I was going to use a word then, but I'm not going to, if it's not complete, then you have an opportunity at the first hearing to raise a questionnaire. So to ask questions of documents that you think might be missing, or clarification on any issues that are within that document. And again, the court will order that those questions are responded to. So we can kind of go down that route. Now, if you have an ex-spouse who you've issued proceedings with, they've been served with the application, you've got evidence that they've been served with the application, and they are still ignoring you and not filing the documentation, then at that stage, we look to ask the court to attach what we call a penal notice to the requirement to file the financial information. And a penal notice comes with a very big warning. And to put it very briefly, if you breach a penal notice, then you can be committed to prison for contempt of court, effectively. So it has really, really serious consequences attached to it. And I think just before, Matt, you were saying that there had actually been a case very recently dealing with that. So do you want to go through that with us?
Yeah, I mean, there's a recent one, and I was just trying to find it before. I couldn't. Sort of the most well-known case in sort of family law, where there has been a party imprisoned for contempt of court, is a case of Young and Young, which is sort of 2015, I want to say. And this was a big money case where the husband, Scott Young, said that he previously had millions and millions, had gone bankrupt, and the wife, Michelle, said, I don't believe that's true. I think you've got it stashed away. And he ended up being imprisoned for, I think, 6 months imprisonment in the end, because he failed to comply with so many orders. So it's a rarity. I can't say I've ever dealt with it in my career, although I was just saying off air to Lisa is that I do have a case at the moment where I'm acting for a wife, and the husband, who's still in the same house as the wife, has made it very clear to her and to us in emails that probably aren't suitable for hopefully a family-friendly podcast, given some of the language, that he has no intention whatsoever of engaging and no intention of complying with his Form E. So we're heading up to a hearing in not too long, at which we're going to say to the court, look, we need a penal notice on this order, so you've got a second attempt to provide your Form E, and if you don't, then we can apply back to court for him to be committed to prison. Now, frankly, how much good does that do my client in the long term? Not a great deal, because it still doesn't end up with her getting the information that we need to be able to sort out the finances. Although, of commonly what happens with these committal applications when they go ahead is if someone is sent to prison for contempt of court for not providing certain things, certain disclosure, they can purge their contempt and be released by prison by doing that. So, there is still an element of a stick and carrot with that. But those are the most extreme cases. Generally, it doesn't go that far. Something else that can be done is if someone isn't engaging at all, and this is sometimes a more sensible route, and I have been involved in a couple of cases like this. In cases particularly where there's low assets, so I once represented a wife who had, a house and a pension and, standard stuff, not a huge amount, and her husband had left her a number of years ago and was living overseas in another country and was impossible to trace. And we just couldn't get him involved in the proceedings. We managed to contact him. He did make some engagement, but he refused to engage in the proceedings. Well, we asked the court to make orders in his absence. We said to the court, look, court, we want, and my client had these assets, we just want an order which is the clean break, which means that my client will keep her assets and they can't be claimed because she needs the finality. And the court made that order to say, well, he's had the chance to make claims against his assets and he hasn't. So that's the other option, is you can make orders in absence, but it is a palaver, technical legal phrase there. It is an absolute palaver to go through it all, and it takes longer and it's more costly, and it comes back to what we always say, that the best way to deal with these things, there's a great irony to these sort of non-engagement cases, because most of the time is, I'm not going to engage because I don't want to spend the money on lawyers and it's going to be too costly and too expensive, I'm going to lose everything. That's the kind of the mindset by and large, and it ends up costing more in lawyers because it's more complicated, taking longer because the court's going to give that person more time to do it, and they're going to end up getting penalised in costs and still kind of having to give up the same kind of assets, probably that they, or possibly even more. So it's a really sort of self-defeating process. Have you ever acted for someone who was resistant to getting involved in giving disclosure? So something I get asked quite a lot, and I have to say, I've not really had that. No, not hugely, no. Or I'm very easily fooled by my clients is the possibly the other answer. But the odd little bit of reticence, but normally I'm quite able. Not that I'm quite able. I'm just quite fortunate the client will listen to just do it because that's what you have to do.
Yeah, no, I definitely have had clients that have been difficult when providing documentation, and will say things like, "I've already given you that," when they clearly haven't, or, "Well, they don't need that," and it's like, well, just provide the document, and then that proves that it is what you've said, and then we can sort of move on. No, I don't want to. And it can be really, really frustrating, and it puts us in a bit of a difficult position to a certain extent as well, because we can't advise them properly if we don't know what the information is. And we kind of know that the judge is going to lose his patience or her patience. We know the other side are going to start, issuing questionnaires and schedule of deficiencies and all the rest of it that we're going to end up having to complete. And sometimes you can say until you're blue in the face that this is going to cost you more in the long run, but they can be so entrenched with their position that it's that whole, you can take a horse to water but you can't make it drink, unfortunately. So yeah, I do have do have a little bit of experience. Fortunately not a huge amount. It's certainly not most of my clients, but there are the odd few.
Yeah, I think it's a tricky thing to do, and I can understand try and put myself in the shoes of someone going through this. It's a stressful process, and sometimes the questions do feel, irrelevant. Mm-hmm. They do feel extensive. Sometimes they can be irrelevant. I certainly feel sometimes that questions that are being asked of my client are irrelevant. I'm sure I've asked irrelevant questions before, not with the intention of it being irrelevant, just, you're trying to cover all bases and see what you can find. The best response to that is to answer it. And I do sometimes say to the client, look, ask a stupid question with a stupid answer and be slightly, not being facetious, but you want to just back that down, because giving the answer disposes with the question. If you don't answer a question, the instant reaction is, well, there must be a reason they're not answering the question, and you suddenly think there's something there. So, it is kind of honestly the best policy approach, I think, in terms of getting through the process quicker and easier, for all that it must often feel like, right, I want to push back, I'm not answering this, I've done enough now, I'm fed up. But yeah, it can be really tricky, and it's one of those areas when you are acting with spouses playing by the rules and they feel like the other party isn't playing by the rules. It feels deeply unfair, doesn't it?
Yeah, it can be really unfair, particularly when you're asking your client to do things. And like you say, the response you get is, well, they're not doing it. Why aren't they being told to do it? And it's like, well, we just have to present our case in the best way possible, because ultimately these things do tend to get dealt with further down the line. But yeah, no, it is definitely. And the other thing I suppose to mention is in relation to inferences. So if one party isn't providing something, so for example, if they won't provide an up-to-date CV value for their pension or whatever it is, and they've been asked to and they haven't done it, then one of the other things that the court can do is draw an inference that they haven't provided it because it has indeed gone up in value.
Yeah.
Probably pensions is probably actually a bad example of that. But yeah, you know, if you won't provide a valuation for an asset that you've got or something along those lines, and the other party's saying, well, I think it's worth £50,000, and your client's saying, well, it's not worth £50,000, well, unless they can produce a valuation for that asset, the judge may well say, well, I'm going to take the other party's view on it, which can again put them in a worse situation than if they just answered the question.
It can. I think the classic one that I've had on that front is bonuses, where someone said, did you get a bonus last year? And they've ducked the question, or they've failed to provide the evidence, or they're not providing a bank account that looks like it might have it, something like that. You know, it can often be somewhere where you draw the inferences. And I think the difficulty, though, from the disclosure, from the good, let's call it goodies and baddies, because apparently I'm still 5 years old, but from the sort of the person who is doing it properly, is you ask these questions, to get the payoff for that, to get the court to draw adverse inferences, it's got to be a final hearing. So it's like 18 months plus down the line. So, you know, as a lawyer, and this is probably a slight lawyer win, just spend months and months going, don't worry, we'll be fine, we'll get to the end. And my client's thinking, Matt, this has been a month, he's getting away with murder, and you finally get to the end, you go, see, it all makes sense in the end, and then it pays off, or sometimes it doesn't, and then that's really difficult. But
equally, you might settle before that, and then it can feel very unfair that they, you know, that nothing has been done in relation to their litigation behaviour, let's say.
Yeah, absolutely. So, I mean, top tips then, if you are listening to this and you're not a lawyer actually running the process, if you are thinking, my wife's not going to respond to this, or she's not getting engaged, or my husband has just told me that he will not, you know, he's going to rip up every bit of paper he receives, what are your sort of top tips for people to deal with that themselves?
I mean, I think if you know that's going to happen, then just getting on to issuing your application. There's no point going backwards and forwards with somebody that's made it perfectly clear that they're not going to engage and they're not going to do what's required. So get your application issued so that you can start to get the court with you, and the court making those directions at the first hearing. If they haven't done it, then as we said, we can get, you know, you can ask for a penal notice to be attached to it. So I think that's the main thing, is just don't wait around forever hoping that they're going to suddenly become reasonable, because you're effectively losing time and you're elongating the process for yourself.
Yeah, completely. I think, I guess my advice would be more of a kind of, I think that's completely right in the process, more of a mindset thing. So, you know, focus on what you can control. You can't control the way your spouse acts. You know, none of us can. All that we can control is the way that we act and the way that we react to other things. So it's about, if you're in the knowledge that your spouse is going to be behaving like that, then making sure that you are not rising to the bait, that you are expecting that. Working with a divorce coach to deal with that is really super helpful. And just focusing on saying, okay, I'm just going to control what I can control. I'm going to do the things that I need to do to present my case in the right possible way. And they are going to do their thing, and I'll react to that as much as I can, but I'm not going to fly off the handle at it. Easier said than done, really hard to do that. But I think trying to keep control of what you can control in the process is a key to kind of retaining sanity a lot of the time.
So that's it for this episode of Stowe Talks. Thanks for listening. If you would like more information on our podcasts, head over to stowtalks.co.uk, and please rate, like, share and review this podcast where you can.